Just to also tell everybody that you know the admittance exam for the attorneys has been postponed. This exam has not been postponed. We just got confirmation today. It will still take place on the 1st of September and the 8th of September. So there won't be any postponement of these two papers that are going to be written on the 1st and the 8th of September. Before we commence, I just also want to say to everybody, I see we're going to have about 100 people today, that Mr. Anton Tron, who is the convener of the conveyancing exam, will be doing a short presentation in our last session. That is the fourth session. He will be giving you the opportunity to ask him questions. Usually you ask him what's in the paper, and he doesn't tell you what's in the paper, but he sometimes does tell you what's important and what's not important, and what you must concentrate on and what you must not concentrate on. So please just keep that in mind as well. For those of you that are of the opinion that you can obtain a recording of the sessions after the sessions, Lead has informed us that that is not going to happen. So although the sessions are recorded, it will not be available to any candidates to obtain a recorded session or a recording of the sessions subsequent to my presentation as such. So ladies and gentlemen, those are our house rules. As I said, keep yourself muted, keep your camera off, and questions and answers after the session. We are today going to do the syllabus of the first paper. What I mean by that is we're going to go through all the statutes, and we're going to discuss what is important, how to approach these statutes, how to interpret these statutes so as to be able to answer the questions in the first paper. Now we know, and I don't have to tell you this, the majority of you do know, that there's a first paper which is going to be written on the 1st of September, which consists of short questions, is designed to test the knowledge of the candidates on various statutes, ordinances, decided cases applicable to conveyancing. It'll be 100 marks. Now, I think ordinances is a misnomer, because they cannot ask you any questions on ordinances in this exam. We know that the municipal ordinances have actually now been repealed and been superseded by SPLUMA, and SPLUMA has bylaws, and every municipality has more or less its own set of bylaws, which are actually the regulations that that govern the SPLUMA Act, which is an umbrella act. But we will be dealing with SPLUMA as an act when we get to that part of the statutes. So yes, this first paper, which is concentrating on the statutes and going to be more or less short questions, but that does not mean that you do not have to study the Deeds Registries Act and the Sectional Title Act, because the Deeds Registries Act and the Sectional Title Act are the two acts that actually govern the whole of our conveyancing sphere. So you'll have to have a good working knowledge of the Deeds Registries Act and the Sectional Title Act to be able to do the first paper as well. Having said that, the only thing that they cannot ask you in the first paper is to draft deeds and documents. They won't ask you to draft a power of attorney or an application, or but that does not detract from the fact that they can ask you to describe parties in deeds and documents. They can ask you to draft extending clauses, because that is part of, if you look at the Deeds Registries Act, it is part of Regulation 26 and the forms in the Deeds Registries Act as such. So please do not think that you can go into the first exam and not know and have a good working knowledge of the Deeds Registries Act and the Sectional Title Act. Before we commence, I get the question many times, what must I have in front of me to prepare properly for this exam? Now, Andries has sent you the documentation for purposes of this course. But remember, this course is not the alpha and the omega of the conveyancing. This is what I call polishing the marble or sharpening the sword. So we are just now giving you assistance how to go about writing the exam, not giving you everything that you need to prepare for the exams. And after these 4 weeks or 7-hour session, you're going to think, now I can go write the exams. You're making a grave mistake if you're going to think that you can sit through these 4 sessions of mine and then you will be prepared for the exams. That is so far from the truth, it's not true. Okay? So what must I have to prepare for these exams? They have already given, Andries has sent you the 2021 syllabus. You've got the syllabus. But the syllabus, ladies and gentlemen, I always equate that with 1,000 pieces of a jigsaw puzzle. And you don't know what the picture looks like. And for that purpose, I have prepared a document which Andries has also sent you, which I call Guidelines to Prepare for the Conveyancing Examination. And I start you off with the deed of sale. And I take you through the whole of the syllabus up until where we end with old exam papers and the statement of account. So that syllabus and the preparation, how to prepare for the conveyancing exam, that will give you the skeleton. But now, where do I get the flesh to put onto the skeleton? Where do I find the flesh? Now, all of you must have something already, be it Gawie Leroux's notes, and I see there's a Mr. Spolman as well that's handing out manuals, etc. For this course, I have obviously, I say obviously, I have prescribed my book, because I find my book takes you through the whole of the syllabus, gives you the conference resolutions, gives you the chief registrar's circulars, gives you examples of all the deeds and documents that you need to prepare for the exam. So, but I'm not being prescriptive to say to you that you must have my book. I'm saying to you, you must have the necessary documents to put the flesh onto the skeleton, be it any documents which is sufficient, that you find sufficient. I'm not saying that this was sufficient or that is sufficient. You need to make that out for yourself. That you need the Deeds Registries Act and the Sectional Title Act and the regulations thereto, that's a given. Somebody asked me the other day, and I just can't understand this. He says, where do I find the Deeds Registries Act? Guys, if you now don't have the Deeds Registries Act and you don't have the Sectional Title Act, I think you must postpone this exam till next year, March or April, or when it's going to be written. Because at this point in time, you should have a good working knowledge already of the Sectional Title Act and the Deeds Registries Act. Then in your curriculum as well, you will see that Andries has prescribed the Conveyancing and Notarial Practice Courses 2021 legislation for lead. Now, this is actually what we're going to do today. We're going to look at this legislation for lead, which the first paper is based on. So this is the statutes, and you must be able to apply those statutes to a practical conveyancing scenario. It's no good studying those sections off by heart and being able to recite them like a parrot and not know how to apply it in practice. That is what I am going to try during this 2 hours that we have today, to go through those statutes with you, not the Deeds Registries Act, not the Sectional Title Act, because that we're going to look at when we do the other 3 sessions, when we do our drafting of documents. Once again, not saying that it's not necessary to have a knowledge of all the sections and all the regulations in the Deeds Registries Act and the Sectional Title Act. So now we've got our syllabus, we've got our documentation from which we are preparing, we've got our statutes, because we need those statutes or the extract of those statutes for us to be able to prepare for the exam. Where do we get it? We'll have to Google it, we'll have to buy this conveyancing legislation book, but we'll need to get it somewhere. And hopefully you've got it already, be it in Gawi's notes, be it wherever you are, or be it that you got the conveyancing and notarial course. Now, just a small advertisement flash, and I hope Andries can perhaps tell me if he's already done this. LexisNexis, who has who publishes my book, has decided to give every candidate that is enrolled for this course a 15% discount if you want to purchase this book. All that you must do is Andries will send you the link, and you must obviously say that you're a candidate in this course, and if you buy the book, you automatically get the 15% discount. That was just an advertisement flash, okay? Busiswe, please put off your camera, because now we're watching you and they don't want to watch me, they only want to watch pretty ladies.
Oh, okay, I'm just...
Busiswe, put off your camera.
Oh, sorry.
Thank you. Okay, guys, so as I've already said, what are we going to do today? We're going to look at, Mr. Pinar, put off your camera, please, and you can take off your mask. Please mute, please, guys, I ask you, please, when you enter this meeting, please put off your cameras and put off your mics, otherwise I cannot present. Right, so let us look at the first paper now, and this is just a few guidelines to you before we start with the statutes. Guys, you get 15 minutes to read through your paper. I say to candidates, and please, those of you that have attended these Zoom meetings of mine in the past, this might sound like a repetition. It is a repetition. Take in a green Koki or a highlighter and an orange highlighter and a red highlighter. You can answer the questions in any form, in any format as you wish. You don't have to start with number 1 and end with number 20. You can start with number 20 and end with number 1, if you understand what I mean. So I say, highlight those questions that you can answer very well and make it green. Those that you're not 100% sure of, make it yellow or orange or whatever. Those that you have got no clue of, make it red. And then start answering those questions that you can answer to the best of your knowledge first. That also creates a good impression. Please put off your mics. Please put off your mic. Are the mics off? Mr. Chonga, yeah, your mic is off. Okay, so you got your green, you got your yellow or orange, and you got your red, and obviously you will answer your questions in that format, and then perhaps you're not even going to finish, if you understand what I mean, and then you won't be able to answer the reds, but it will create a good impression with the examiners if you start off and you answer your questions precise, correct, fully, etc. Having said that, we're going to now start, and I want to now share something with you. So I'm going to share the syllabus with you. So just give me 1 second quick. So guys, I hope I've shared the screen with you. So Andries, I hope everybody can see this now. We've gone through the introduction. They say you also need to familiarize yourself with the conference resolutions and chief registrar circulars. Now you're going to ask, where the hell do I find these conference resolutions and chief registrar circulars? Guys, we have sent you the last 5 years conference resolutions, which I think should suffice, except obviously if you look at all the writings and my book, you will also find the relevant conference resolutions reflecting the practice as such. The registrar circulars, we've sent you a few of the most important chief registrar circulars, but I will be alluding to more chief registrar circulars as I go through the syllabus with you as such. You also know that the examination criteria is that if you get more than 50% in both papers, you pass both papers. If you get between 40 and 50, you can get an oral. And if you fail, that paper can be held over for you for 2 years. Right, that's the pass requirements, the times we've already gone through, the requirements we've gone through. Now, ladies and gentlemen, I'm looking at the syllabus, and I'm going to start with the necessary legislation that you need to have a working knowledge of. Now, the first, and I'm going to break down this syllabus even more. The first act that we look at is the Administration of Estates Act. That is the act that now governs deceased estates. So when you are preparing your estate transfers, you have to have a very, very good working knowledge of the Administration of Estates. Section 1 of that act provides a few definitions. Look at the definition of property, look at the definition of real right. So section 1 is not so important for purposes of the exams. But then we come to section 3512. Ladies and gentlemen, this is your liquidation and distribution account that must lay open for inspection. And 3512, you must actually read in conjunction with section 42.1. Not only with section 42.1, you also have to read it in conjunction with regulation 49.1F of the Deeds Registries Act. So I'm saying 3512, make a cross-reference from 3512 as well as to 42.1 of the Administration of Estates Act, as well as regulation 49.1F of the Deeds Registries Act. Because 3512 says the L&D account must lay open for inspection, free from any objection, and 42.1 says a conveyancer must give a certificate to that effect. And the Deeds Registry says how that certificate must read for purposes of their prescripts when you are doing an inheritance. So 3512, I've already said, read in conjunction. Then if we come to 37, that's massing and ideation. Now we're going to, when we do estate transfers, I'm going to once again concentrate on massing and ideation, massing and repudiation, and what the consequences thereof is for drafting deeds and documents. So all that you must know is that section 37 provides the authority for massing and ideation. And what are the requirements for massing and ideation? That is what section 37 sets out. Section 38, important. It hasn't come up in the exams in the past, and I usually get a strange feeling that at some point in time they're looking for new questions and section 38 might raise its ugly head. Now, what is section 38? Section 38 is a causa for an estate transfer. What would the causa be in terms of section 38? It is when a person dies and the property is bequeathed to minor children. However, the deceased was married, and the parent of those children must take over that property so as to look after the children. And for that, in that instance, the causa would be that the wife is entitled to the property, 1/2 share by virtue of a marriage in terms of the marriage in community of property, and the other half she takes over in terms of section 38. Usually that surviving spouse provides security to the master, which is held in the guardian's fund until the minors are reached the age of majority and it's paid over. If she hasn't got sufficient security, that a mortgage bond is registered in favor of the master for purposes of the inheritance of the children. So what am I saying? Section 38 is a causa for an estate transfer or a transfer by endorsement in terms of section 45. We'll look at section 38 again when we do estate transfers. Section 39, here we're looking at specifically Section 39.2 and Section 39.3, which, ladies and gentlemen, is caveats that's noted against the deeds registries, against the title deed of property. And the causes there is if the heirs are unascertained, or whether Section 30, that's 39.2, 39.3 is when it will have an undue hardship on the heir to take transfer, then endorsements are brought in terms of Section 39.2 and Section 39.3. But we'll touch on them again when we do estate transfers, because that is two of the applications that you will have to bring. Then we come to Section 40. Important. Here you put an NB next to it, specifically Section 41B, 40 in brackets 1B. This is when a mortis causa trust is created and the property must be transferred. Now I'm using the word transferred in inverted commas to the mortis causa trust. It is an application that is brought by the executor to record the terms of the will against the title deed of the property. The deeds office does not regard this as a pucker transfer. It is regarded more or less like a caveat, but there's a lot of discussion still surrounding that. But Section 40 we'll get onto again when we do our estate transfers. Then Section 42.1 and Section 42.2. Section 42.1 is the certificate, and you must be able to draft the certificate in line with Section 35.12 and in line with Regulation 49.1F for purposes of an inheritance. If the property is being inherited, you don't have to lodge the L&D account. You give a 42.1 certificate to say that the property has been set out in the L&D account, which L&D account has been advertised and has laid open for inspection, and no objections to this inheritance has been received. That is for all inheritances. This is a supporting document that you will lodge with the Registrar of Deeds. 42.2 is when the executor, or let me put it this way, when there is a sale out of an estate, when there's a sale out of an estate, then the master must endorse the power of attorney in terms of Section 42.2, that he or the master has no objection to the transfer of the property. So please put off your mic. Please put off your mic. So please differentiate between Section 42.1 when you will give a certificate by a conveyancer and when you will need to give a 42.2 or obtain a 42.2 endorsement from the master. And then you must also know, because this question has been asked many times in the past, that J29 or what it's called that you submit to the master. What information must you submit to the master for the master to be able to give you your 42.2 endorsement? Please keep that in mind. Section 49, an important section to know that an executor or his spouse or his employee cannot buy property out of the estate without an order of court. So all that it says is, Section 49 says that if the property is being sold by the executor cannot have a vested right in the acquisition of this property. So he cannot buy it, his spouse cannot buy it, his employee or employer cannot buy it, so unless the master approves that. But that usually, when you ask for your 42.2 endorsement, that is Section 49 is covered in your 42.2 endorsement. But you must know that that's one of the requirements to get your 42.2 endorsement. Section 80 of the Administration of Estates Act. Guys, if there's one section here that I put a big NB next to, and that's Section 80, because that governs the authority of a minor or a person who's mentally incapacitated to deal with property, or their duly representatives to deal with property that belongs to them. Now, we know that a minor under the age of 7 has no authority to act as such. So you have to read Section 80 together with the Children's Act, specifically Section 18 and 18 capital A of the Children's Act, to say children, minor under 7, no capacity, and if he's dealing with immovable property or alienating immovable property, both his parents must assist him. Over and above the assistance, the upper guardian of the minor, that is the master, if the value thereof is under 250,000, if it's above 250,000, High Court order. So too with a mentally incapacitated person. If the curator is dealing with a property, he gets his authority obviously from his letters of curatorship, but if the value is over 250,000, High Court order, under 250,000, obviously, once again, the master can approve that. So why I've taken so much time, and you're going to tell me, Jannie, you've almost spent half an hour just on the Administration of Estates Act. Guys, I can tell you now categorically that you're going to get some kind of estate transfer or estate question in both your exam papers, because it is a reality that we have to die at some point in time. So that is I would say a percentage of our conveyancing is based on estate transfers. So yes, estates is important. The administration of estates is very important. So I'm leaving the Administration of Estates Act, and now I'm going and I'm looking at the Advertising on Roads and Ribbons Development Act 21 of 1940. Now, the authority, or the controlling authority, if you look at Section 1, Section 1 gives you a few definitions, and the one definition is the definition of controlling authority. Who is the person that gives consent in terms of Act 21 of 1940? Now, there was a very, very important court case sometime beginning of this year, which said the controlling authority is now the local authority. So the local authority is the controlling authority that actually polices the Advertising on Roads and Ribbons Development Act. Now, you'll note that only Section 1 and Section 11 has been prescribed. Section 1 is the definition, and I've already said you must know what the definition is of controlling authority, and you must know the definition of a main road and the roads that are governed by this Act. Then Section 11, 1 to 3 says property or immovable property or land within 95 meters of a building restriction road, which is obviously a main road or national road, cannot be subdivided without the controlling authority's consent. 11.4 says that property within 95 meters of a building restriction road cannot be transferred to 2 or more persons without the controlling authority's consent unless it is an inheritance. Section 11.6 says the local authority can impose certain conditions, and it tells you what conditions can be imposed. And 11.8 and 9 tells you that those conditions can be cancelled. So all that you have to, and if the whole discussion on Act 21 of 1940, or the Advertising on Roads and Ribbons Development Act, is set out in my book. Who the controlling authority is, what conditions can be imposed, what exemptions are there in terms of Section 11.4, etc. So I advise you just to look at the definitions and Section 11, and as I said, 11, 1 to 3, which is, you can read it as 1, 11.4, which is the undivided shares, 11.6, the imposition of conditions, and 11.8 and 9, the cancellation of those conditions. The next act we're looking at is the Agricultural Holdings Registration Act 22 of 1919. Here is the good news. They cannot ask you anything in the exams on this act, because this act is not a national act. It is only an act which is relevant to the former Transvaal. So in your written exam, they won't ask you anything on the Agricultural Holdings Registration Act of 1919. But if you do, and I hope it never happens, that you do get an oral, they love asking you, specifically the candidates in the former Transvaal areas, questions on the Agricultural Holdings Act. The Alienation of Land Act. Guys, this is also, if I say the Administration of Estates Act was important, the Alienation of Land Act is extremely important. First of all, because here they've said to you the entire act is important. First of all, we have to look at section 1, which gives us the definition of alienate and alienation, gives us the definition of land. For purposes of chapter 2 and 3, it gives it a definition of registrable. So the definitions, very important. I've got a whole chapter in my book on the Alienation of Land Act. So I advise you to specifically look at that chapter. I'm going to just quickly go through the relevant sections. Section 1, as I said, is the definitions. Section 2 tells you that any dealing with land or immovable property must be in writing, signed by the transferor and the transferee. And we know as well that there's numerous case law, etc., that says you cannot electronically sign an offer to purchase or a deed of sale, because it says it must be in writing, signed by both the purchaser and the seller, or the transferor and the transferee. So that is section 2. Section 3 gives you the exceptions to section 2, which, when does it not have to be in writing? And here you have to look at auction sales. You have to look at companies buying property for a company still to be incorporated. And there you have to look at your Companies Act, which we will look at a bit later. Then you go to section 6. Very, 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 very important. If property is being sold in installments, meaning a contract, and a contract is defined in property being sold in more than 2 installments over a period of longer than a year. So minimum of 3 installments and a minimum period of 1 year and 1 day. Then section 6 tells you what must be contained in that deed of sale. Specifically look at section 6.1g or 6g, I think it is, the 5-year period, that it cannot exceed 5 years if the property is not registrable. But you can record a contract against property which is not the subject of a separate title deed, provided all the legal requirements have been complied with thereto. Meaning, is that property registerable? If it's registerable, it means it complies with all the legal requirements to be able to obtain a separate title deed in respect of that property. Having said that, look at 6.1g or 6g. If it isn't capable of being has a separate title, there's a maximum of 5 years. Section 9 and 10, if the property is subject to a mortgage bond, what is the requirements that must take place there? Section 14, look at the provisions of intermediaries when property is being sold, successive purchases. Section 15, 16, 17, not so important. 18, not so important. 20 is your most important section in your Alienation of Land Act, because that is the recordal of a contract. Now, if you go through your old exam papers, how many times have they asked, who can record a contract? Against which land can a contract be recorded? Now, we know it must be used mainly for residential purposes. It cannot be recorded against agricultural land, that is agricultural land as defined in section 1 of Act 70 or 70. It must be used, as I said, mainly for residential purposes. Within what period of time must it be recorded? It must be recorded within 90 days of it being registerable as such, or within, if it has to be registered in the name of an intermediary, after 90 days in the name of the intermediary. So look at section 20, who can record the contract? And then you look at section 21C, who can cancel the contract? And when can what is the purchaser's remedies if the contract is not recorded within the necessary 90 days? He has 14 days to cancel it or to record it himself. So he can start recording that contract against the title deed from day 91. He doesn't have to wait for the 14 days to pass. It starts by day 91. So once again, section 20, the whole of section 20, very important. Section 25 and 26, specifically when money cannot change hands until the contract has been recorded. And there was recent case law. I don't know who of you get my regular updates on case law, etc., but there was a recent court case which said any money that changed hands before the contract has been recorded must be given back, and it is absolutely not allowed. You're not allowed. It is an offence to pay any money over to the seller of the property until the contract has been recorded. 29A is the against which property can the contract not be recorded. Just look at the provisions there of 29A, but it is so outdated at this point in time. Any property over the amount of 250,000, etc. But look at the provisions of that section as well. So I reiterate, the Alienation of Land Act, very important. The Births, Deaths Registration Act, section 23 to 26. Guys, here I want you to study this section 23 to 26 together with section 93 of the Deeds Registries Act. When we do our drafting and drawing seminar or our Zoom consultations, we will be looking at section 93 again. But specifically, when is it necessary for a woman to, if she elects to change her name, must it be recorded against the title deed? If I want to change my surname, what are the requirements for me to change my surname? If it's a company, how does the company change its name, and how is it recorded against the title deed? So I say once again, section 23 to 26 it relates to a change of name. When is it peremptory, and what are the requirements? Must be government gazetted, etc. There are certain name changes that do not have to be government gazetted, and I usually say a woman or a lady has a divine right to change her surname at will. If she marries me, she can assume the surname of West. If her surname was East, she can elect a double-barrel surname of East-West. If she divorces me, she can revert back to her surname of East. So you can see a woman has a divine right. And many people ask me, when does a woman's surname change? The day she gets married, she has the right of election to assume her husband's surname, or retain her maiden surname, or assume a double-barrel surname. Thereafter, she must go to Home Affairs and get a new identity document. But the identity document does not give her the right to use that name. She can use that name prior thereto. There's certain affidavits that follow on with that. So that is the Births, Deaths Registration Act. The Black Communities Development Act 4 of 1984, you will tell me, what the hell is this act still doing here? It has been repealed, except for section 53 to section 57B. And those sections have also now been found to be unconstitutional, in the sense that I don't know who of you have read my articles on the Constitutional Court case of Rahubi. Now we know that a leasehold, the granting of a leasehold, soon as a township register is open, it is automatically upgraded to freehold and the person becomes a freehold owner. The Rahubi case has now found that that is discriminatory against women and therefore it is unconstitutional. The 18-month period which they gave the Department of Rural Development to change it has passed. We haven't seen anything. So I'm saying to people, leaseholds, grant rights, informal rights, etc., that are automatically upgraded into freehold is at this point in time a bone of contention and we don't touch it. So I very much doubt in the exams if you will get anything on the Black Community Development Act, specifically sections 53 to 57, read in conjunction with the with ULTRA, that is the Upgrading of Land Tenure Rights Act, which I will touch on a bit later. Just know that the upgrading of leaseholds is now found unconstitutional. The granting of leaseholds, that can obviously still take place and does still take place in terms of section 53 to 57B of the Black Communities Development Act. The Children's Act, ladies and gentlemen, there I say to you that they've cut it down to between section 17 and 21. I believe that section 18 is the most important section there, governing minors and who must act on behalf of minors who are alienating property or acquiring property or entering into anti-nuptial contracts or whatever the case may be. So look at section 18 specifically section 18 capital A. Then we come to the Civil Union Act. And this act has been asked so many times, not only in your first paper, but also in your second paper, because, and here I refer you to, for the Civil Union Act, I refer you, and as long as you can study Chief Registrar Circular 1 of 2007, we've sent that to you. Chief Registrar Circular 1 of 2007, because that will tell you whom, well, you have to look at the definitions of a civil union, who may enter into a civil union, who may solemnize a civil union, and how do you describe persons who have entered into a civil union. Now, there's a bit of confusion here. Somebody the other day said to me, isn't a civil union also like a domestic partnership? And I said, our law does not recognize a domestic partnership or whatever you want to call it. The Civil Union Act, although it is an act which any heterosexual person can also get married in terms of, because it is not an act only for persons that are not heterosexual. So therefore, you can enter into a civil union which has the consequences of a marriage or a civil partnership. And this is where the big confusion lies. When I get married in terms of the Civil Union Act, I have to, when my marriage is solemnized by the marriage officer, I must say to the marriage officer, we are entering into a marriage. If we enter into a marriage, it is a marriage in community of property or it's a marriage out of community of property. If I've concluded an antenuptial contract prior to the solemnization of the marriage, and that antenuptial contract has been registered in the deeds registry within 3 months of the date of execution, then I'm described as Alan Stanley West, identity number, married out of community of property, just like anybody else is described in a heterosexual marriage. If I decide we're not going to enter into an antenuptial contract, I'm going to be described as Alan Stanley West, identity number, and my spouse, full names, identity number, married in community of property, exactly the same as anybody else. However, if we say to the marriage officer, we do not want to, we elect not to enter into a marriage, but a civil partnership, not a civil union, a civil partnership, which has the consequences of either a marriage in community of property or out of community of property, then there is a different description of me and my spouse if we've entered into an antenuptial contract, or if we have not entered into an antenuptial contract. And that is all set out in Chief Registrar Circular 1 of 2007. So look at the definitions in the Civil Union Act, and then you study Chief Registrar Circular 1 of 2007 and know how to describe your parties. Because if, and this has a ripple effect. If you get it wrong in one document, if you're going to draft your deeds and documents in paper 2, and it follows on, it's going to be incorrect all over the show. So please differentiate between a marriage and a partnership. The Close Corporation Act. Now, this is one of the acts that we know doesn't exist anymore since 1 May 2011, when the new Companies Act came into operation. But you can still convert a close corporation into a company. So please look at the provisions and the requirements for converting a close corporation into a company, and whether financial assistance can be afforded to members of a close corporation for purposes of acquiring property. That's section 40. Also specifically look at if a close corporation, and this question I also get some kind of feeling sometimes, if a close corporation has only one member and that close corporation sold the property during the lifetime of that member, who must pass transfer of that property to the new owner? Now we know that the Close Corporation Act, specifically section 35, which is not prescribed, says that the executor steps into the shoes of the sole member and he can pass transfer thereof. With a company, it's totally different. The executor must be appointed as a director before he or she can transfer the property. The Collective Investment Schemes Control Act, section 52 to 62. Guys, here I say to you, this is the act that governs participation mortgage bonds. And there's a Chief Registrar Circular on the Collective Investment Schemes Control Act. You don't have to go study section 52 to 62. Just go study, and I'm going to ask my colleague, can you remember the Chief Registrar Circular? Oh, do me a favor. There is a Chief Registrar Circular. I want to give that Chief Registrar Circular to you because it's important that you know. And I think it was issued somewhere in 2003. So I'm just checking in my book here, collective. Here it is. Sorry, I've got it. It's Chief Registrar Circular 15 of 2003. So right there, Chief Registrar Circular 15 of 2003. I'm going to study only that circular because that circular tells me for a participation mortgage bond, can I see the participation mortgage bond? What is the minimum amount? In whose name is a participation mortgage bond registered? Etc., etc., etc. So I'm breaking it down for you. I'm saying just go study Chief Registrar Circular 15 of 2003. Guys, you're very fortunate because the Companies Act, if you wrote the exam 2 years ago, the syllabus said you must study the whole of the Companies Act. Now, with all due respect, I mean, I don't think you have time to read through the whole of the Companies Act. They've now broken it down for you in certain sections. I even break it down further and I say, please study Chief Registrar Circular 28 of 2013. That gives you all the practice and procedures with regard to describing companies, mergers of companies, change of name of companies, etc., etc. However, there are other sections that is not in that circular which is specifically relevant to a conveyancer, and that is section 112, 1, 2, and 3. read together with section 115.2. That is extremely important. Those of you that have got Javier Leroux's notes, Javier Leroux's notes has a small extract on how the new Companies Act affects conveyancing and the provisions of Regulation 44A of the Deeds Registries Act. That summarizes everything, and it'll discuss section 11, it'll discuss section 19, it'll discuss section 112, and it'll discuss section 115. Over and above that, I refer you to Chief Registrar Circular 28 of 2013, which I would not go into the exam room without having an extremely good working knowledge of Chief Registrar Circular 28 of 2013. Those of you that have, as I said, have Javier's note, it is a very, very good document for purposes of conveyancing. I'd suggest, if you haven't got it, to get it as speedily as possible. The Community Schemes Ombud Services Act, the following definitions: Chief Ombud, Community Scheme, Service, and then certain sections and regulations. Now guys, the Community Schemes Ombud Services Act, this is an act which allows the Ombud to act as an arbitrator, not the Ombud, to appoint an arbitrator in certain disputes. What disputes? And that is set out in the Act, which disputes the arbitrator can decide upon. I would advise you not to study this Community Schemes Ombud Services Act, but obviously to have a working knowledge of what can be, what disputes can the Ombud have the authority to appoint a adjudicator for purposes of the dispute. So just look at that. The Constitution of the Republic of South Africa. Now, guys, I believe that is one of the most important pieces of legislation that we have. But from a conveyancing perspective, sections 103 and 166, all that I actually want you to know here is that the Constitution clearly says that any property bought on behalf of the state must be registered in the provincial government or the national government. So it cannot be registered in any other sphere of government organization. It can only be registered. Remember, previously we used to register property in departments named the Department of Agriculture, the Department of Water Affairs, etc., etc. If that has been registered in those departments after the Constitution, after 1994, the chief registrar, the registrar made a conference resolution that the title deed must be endorsed in terms of section 31V to vest it in either the national government or the provincial government. After 1994, only provincial government or national government. The Consumer Protection Act. Guys, they've also broken it down into those sections. Yes, it is important from a conveyancing perspective to know who is a consumer, how it affects us as such. Unless you're going for the book prize, I wouldn't concentrate too much on the Consumer Protection Act, because only very few short questions can be asked out of the Consumer Protection Act. The next act, the Donation Tax imposed in terms of the Income Tax Act 58 of 1962. Candidates are expected only to know the rate of donation tax and what exemptions exist. Know that there are certain exemptions between spouses. First 100,000. What is the existing rate? Is the rate of, is it 20? I think it's 22% or 25%. Just Google that and find out what the donation tax is at this point in time, and look at what exemptions exist in terms of the Donation Tax Act 58 of 1962. The Estate Agents Act. The Estate Agents Act has actually now been repealed. And section 32 is that they must have a trust account. We know that there's now a new Property Practitioners Act So I wouldn't concentrate too much on the Estate Agents Act. The Expropriation Act 63 of 1975. Guys, I would not concentrate on the Expropriation Act. What I concentrate on if I look at expropriations is Section 31 of my Deeds Registries Act. The whole of Section 31 read together with prescribed form G of the Deeds Registries Act. So the questions that are going to be asked in terms of expropriation is going to be based on Section 31 of my Deeds Registries Act. FICA, they say the entire act. You must know who is what do they call that person? A responsible person in terms of FICA, that you, and what your duties are as a something institution. How do you FICA a trust? How do you FICA a company? How do you FICA a person that is not a South African citizen, etc., etc. So once again, there are in Gawie, those of you that have Gawie Leroux's notes, those of you that have my book, those of you that have studied the FICA Act, you know how to FICA certain persons, who is the responsible person, what are the duties of a responsible person for FICA purposes, etc. So that is the Financial Intelligence or FICA Act. Formalities in respect of Leases of Land Act. Guys, here they say the entire act. The good news is there's only one section in this act. There's only one section. And you know what that section says to you? It says to you that if you sell property that is subject to a lease agreement, the lessee will have the first right. Or there's this Roman Dutch or Dutch term, hier gaat voor koop. That is what Section 1 says, that if you have a lease agreement over property and the property is sold and that lease agreement is for less than 10 years, the lessee has a right to that property without it being recorded against the title deed. If it's longer than 10 years and it is not registered against the title deed, it is valid for 10 years unless the rule of knowledge applies. Unless the purchaser obviously knew about this, and then it will be applicable for the full period. We know that short-term lease agreements are not regarded as immovable property. Lease agreements for 10 years or longer, or the lifetime of a person, is regarded as immovable property and can be registered against the title, and a mortgage bond can be registered against it. Short-term lease agreements or non-registered agreements, a notarial bond can be registered against it. So once again, the formalities in the respect of Leases of Land Act, yes, questions have been asked about it. The terminology, hier gaat voor koop, or lease goes before purchase, is important for purposes of all conveyances when you're dealing with property. And it's always very prudent in your deed of sale to say that you're giving vacant occupation, okay? Because if there's a lease in that property, that lease has priority above the purchaser of that property. The Housing Consumer Protection Act. There was an extremely important court case the other day on Section 13 of the Housing Consumer Protection Measures Act 95 of 1988. I will be sending Andres that court case, that he can please send that court case out to you, because somebody in I think Section 13 was asked previous exam or the exam prior to that, and one of the candidates sent a very nasty email to the convener and said, why do you ask Section 13 of the Housing Consumer Protection Act? How does that affect conveyancing as such? And just at that point in time, the conveyancer was lambasted by the court for not complying with Section 13. So I say to you, look at the definitions in Section 1 and look at Section 13, specifically your duty as the conveyancer. The next act, the Immovable Property Removal or Modification of Restrictions Act, Section 1. Here, I want to break this down again and say to you the most important section here, ladies and gentlemen, is Section 6. And you know what Section 6 revolves around? It revolves around fideicommissions. That a fideicommission is, or what we call a successive fideicommission, is only valid up until the third generation or the second set of fideicommissary heirs. Thereafter, it vests free from that fideicommission. Now, if you read my book or my chapter on fideicomissions, I've set this out in that chapter on conditions, title conditions, and I've explained it thoroughly. So even if you just study that, or if you got Gawie Leroux's notes, go to fideicomissions, know, and not the other day, I think the last exam or the previous exam, they asked you to explain a fideicommission or what a fideicommission residue is. And somebody said, why the hell are we now need to know what Latin terms are? Why are we not studying? We got a comment from one of the candidates. We're not studying Latin, we're studying conveyancing, and now you're asking me what a fideicommission residue is. Guys, if you do estates and you do estate transfers, you will find fideicomissions and you will find fideicommission residues. You must know how to register a fideicommission. You must know what the implications of a fideicommission residue is on the fiduciarius. Can he sell the property? Is there a restriction? Is the 108th novella of Justinianus? And now you're going to tell me who the hell is Justinianus? Those are our writers of the law, what their requirements are. So I wouldn't go into the exam room without having a good working knowledge of a fideicommission, how to register it, how to cancel it, who must deal with the property if the property is subject to a fideicommission. We will be dealing with that when we deal with Section 69 bis of the Deeds Registries Act in our estate transfers as well. Right, Immigration Act, Section 1, definitions. Definition of a foreigner and an illegal foreigner. You must know what the difference is, because a foreigner is somebody who's in South Africa, but who's not illegally in South Africa. He's got a visa and he's got a passport, etc. An illegal foreigner is somebody that's in South Africa illegally. And that brings us to Section 42, because Section 42 says a foreigner who's here in South Africa can buy the whole of South Africa if he wants to. However, an illegal foreigner cannot purchase any property, and there is an onus on anybody, the estate agent, the conveyancer, who's abetting such a person. It will be a criminal offense, and that is set out in Section 49. A foreigner who is let's say I'm sitting in Nigeria and I'm a Nigerian citizen. If I've got the money, I can buy the whole of South Africa. Once again, the difference between a foreigner and an illegal foreigner. Who can a foreigner acquire property in South Africa? Can an illegal foreigner acquire property in South Africa? What are the sanctions for the persons that that's abetting somebody that's acquiring, that's assisting somebody acquiring property who is an illegal foreigner? So look at Section 1, 42 and 49. The Income Tax, the Income Tax Act. Here they've given you Section 1, 44, 45, 46, 48, 51, 51A, 35A. You know what? I'm saying to you, here Section 35A just screams to me of importance. Why does it scream importance? Because it places an onus on a conveyancer that if the conveyancer does not withhold certain taxes from the seller who is a non-resident, he can be held liable in his personal capacity for that amount of money to a maximum of the amount of money that he would have earned out of that transaction. And so too the estate agent. In terms of Section 35A, first of all, you must know who a non-resident is or who qualifies as a non-resident. What are the tariffs of this tax that must be withheld? If you're a natural person, it's 7.5%. If you're a juristic person, it's 10%. If you're a trust, it is 15%. It's in a directive that you must receive from SARS for purpose. It's actually what we call a withholding tax. It's actually a capital gains tax for persons that are non-residents. So 35A to me, and you know, there's so many conveyances that are not aware of Section 35A, that are selling property of non-residents without withholding this tax, without knowing that they're going to be held liable in their personal capacities for that major fee. However, the fortunate thing is there's a threshold of 2 million rand. It is only for transactions in excess of 2 million rand that you have to withhold this tax. In terms of the Income Tax Act, I want you to read the Income Tax Act specifically for VAT purposes, together with the Transfer Duty Act. When is VAT payable? When is transfer duty payable? At what rate is capital gains tax payable? What is the threshold of capital gains tax? So those are the questions that you're going to have to concentrate on for purposes of the Income Tax Act. 35A, capital gains tax, the tariff of capital gains tax, what is the threshold, what is the percentages? You have to study that for purposes of the exams. The Insolvency Act, ladies and gentlemen, a lot of sections here. But once again, you know, when we do insolvency transfers, I'm going to discuss the Insolvency Act again. But it's important for you to know that if I'm declared insolvent, I have not got the right to deal with the property for a period of 10 years. After 10 years, I'm automatically rehabilitated in terms of Section 127A, and the property reverts back to me without a formal transfer. If in the process of the 10 years I apply for my rehabilitation, then and I see Section 25 has not been set down as one of the sections, but in terms of Section 25, the property vests in my trustee and he must transfer it back to me. So these sections of the Insolvency Act, I cannot say to you how important they are. They are all important for purposes of this exam. 127A, automatic rehabilitation. Section 80 bis, 81 and up until 88, those are the authorities for the trustee to deal with insolvent property. Section 80 bis is obviously a urgent sale and the master approves it in terms of Section 80 bis. Section 81 and 82 is the trustees or the resolution of the creditors at the second creditors meeting. So those are the creditors or the master in terms of Section 82 that approves the transaction. Insolvency Act, important. Our next act is the Interstate Succession Act. Now, I know we are not very good at mathematics. Otherwise, we would have been doctors. Therefore, we studied law. However, in terms of the Interstate Succession Act, it's also only one section, guys, but it's Section 11A, 11B, 11C, 11D, 11E, 11F, and then 12, 16, 18. That's important for you to know. Now, I wouldn't even dare to go into the exam room. Not only for purposes of my first paper, but also for my second paper. If I do not know how to administer a estate in terms of the Interstate Succession Act. Now, 11A says, if I die intestate, that's without a will, and I leave a spouse, meaning I'm married, be it a customary marriage, be it even now a Muslim marriage, even well, obviously a civil union or a foreign marriage or whatever, my wife inherits everything because I only left a wife. If I leave only children, and that includes adoptive children, not children, well, for my purposes, also children born out of wedlock because they are my blood, but not my wife's children that have been born out of wedlock, only my blood. only those children will inherit per capita. If any of those children have predeceased me, representation takes place. Section 1(4). And here it now comes. If I leave a wife, or wives and children, I have to determine how am I married. If I'm married in community of property, my wife gets half of the estate plus 250,000 or child share, whichever is the greater. If I have more than one wife, every wife or each wife receives 250,000 rand or child share, whichever is the greater. If any of the children have predeceased me, representation will take place. If I leave no wives, no children, then my estate goes up, and what we call splitting takes place. Half goes to my mother, half goes to my father. If one of my parents died, then my mother, let's say my father died, my mother will get half, and my brothers and sisters will get the other half. If I've got no brothers and sisters, everything will go to my mother. If I haven't got a mother and father, it will go up to my grandparents, and splitting will take place there again. Until there are no heirs anymore, and then it gets put into the guardian's fund at the master. And if nobody claims it after 30 years, it becomes bona ficatia. And usually you get a call from some gentleman saying to you that you are a descendant of West who died in England some or other time, and you have actually inherited his estate because he's done a search at the master's office. And to obtain this inheritance, you must just put 120,000 rand into his account, and then you've inherited $1.6 million. Guys, that is bull dust. That's not going to happen, okay? That is a scam. I saw the TV advert the other day. Scam, scam, scam. So if somebody tells you that, it's a scam. The Land Survey Act 8 of 1997, guys, not that I don't think it's an important act, but I'm not going to concentrate on that act for the exams. Not at this point in time. Unless you're going for the book prize, study it. The Matrimonial Property Act. If there's one section in this act that I am going to concentrate on, it is Section 15. Together with the case law that also surrounds Section 15 now, that if I sell property and I'm married in community of property and my spouse didn't assist me or give consent, can that transaction be regarded as null and void or ab initio void? So here I want you to study the whole of Section 15, as specifically with regard to sureties and Section 15. Look at specifically Section 15(9) and the case law on Section 15(9) as well. So I don't say Section 1 and Section 11 and Section 12 and Section 14 is not important, but I regard Section 15 as the most important section in this statute. The Recognition of Customary Marriages Act. Guys, if there's one act that has been asked almost every exam, it is the Recognition of Customary Marriages Act. And it says here that you must study the entire act. But I say once again, go look at Chief Registrar's Circular 27 of 2013. Specifically, and there they refer to all the case law. They refer to the Gumede case, they refer to the Mayeleni case, and they give you all the, not the authority, they give you the description of the parties, if they are married in terms of a monogamous customary marriage, if they married in terms of a polygamous customary marriage, if the polygamous customary marriage was before 15 November 2000 or after 15 November, they discuss that in detail, in toto. I have got a whole chapter on my book on black marriages, but we know now that the Section 22(6) of the Black Administration Act 38 of 1927 has also now been found constitutional. So you can't describe a person as automatically out of community of property now, because that has been found unconstitutional. The Chief Registrar of Deeds at this point in time has not issued a circular on this. So as I said, section 22(6) for marriage, for black marriages entered into prior to 2/12/1988, a big question mark is on those marriages, but this act governs customary marriages. And here I want you to look specifically at the definition of a customary marriage. Customary marriage is a marriage concluded in terms of customary law. And then they define customary law. Customary law is the customs and usages traditionally observed amongst the indigenous people of South Africa. Now the question is, can two Nigerians marry in terms of our customary law? No. Can one Nigerian marry a South African lady in terms of the Customary Marriages Act? My opinion, no. Also, many other writers say no. So look at those definitions. That's section 1. Section 2 says what customary marriages are recognized in South Africa. Now we know that this act came into operation on the 15th of November 2000. All monogamous customary marriages entered into, all valid monogamous customary marriages entered into prior to the 15th of November are recognized, and they are in community of property. All polygamous customary marriages entered into before the 15th of November are recognized, and they governed in terms of customary law, subject to the new constitutional court case, which gives certain rights to the wives. All monogamous customary marriages entered into after the 15th of November, provided they comply with the provisions of Section 3. Now, Section 3 says to you what the requirements are for a valid customary marriage in terms of the recognition of customary marriage. Both spouses must be over the age of 18. They must not have entered into a civil marriage. The marriage must be concluded in terms of the customs, usages traditionally observed, which is a very difficult concept, because must lobola have been paid in full? Must the bride have been handed over? There's so many court cases on this. So it's also a very grey area at this point in time. That's Section 3. Section 4 says that there's a duty on the parties to register the marriage. But Section 4(9) says the non-registration of the marriage does not affect the validity of the marriage. Remember that. Section 4(9) says the non-registration of a customary marriage does not affect the validity of the marriage. Section 6 tells you what the consequences are of a polygamous and monogamous customary marriage. And Section 7 also gives you the consequences, specifically the court order that must be obtained for a polygamous customary marriage for the division of the estate. Section 8 says you can only divorce in terms of the Divorce Act if you have married in terms of a customary marriage. Section 10 gives the parties the right to I don't like using the word convert, but yes, let's use the word convert the customary marriage into a civil marriage. So those are the sections of the Customary Marriage Act that you have to have a working knowledge of. The Sectional Title Schemes Management Act. There they've given you the entire act. Here I want you once again to look at Section 1, the definitions, specifically the definition of unanimous resolution and special resolution. Section 2, when does a body corporate come into existence? And how do you describe a body corporate? It's important that you know how to describe a body corporate, because it is a persona, a statutory persona. Then I want you to look at Section 5, which specifically gives you whose consent is necessary for purposes of certain acts in terms of the Sectional Title Act. If you are going to sell common property, if you're going to extend your sectional scheme, if you're going to extend your sectional unit, etc., etc. So look at section 5. Section 10, the whole of section 10, very important with regard to the rules. The rules can be, as in the old section, not in the old, in the 1986 Sectional Title Act, can be reserved in the rules, or it can be reserved on the sectional plan. If it's reserved in the rules, what are the requirements thereof in terms of section 10(7)? So look at section 10. And those are the sections that I'm going to concentrate on the Sectional Title Schemes Management Act. The Share Block Control Act. Now, believe me, this is a question that I thought would never come up, but it has come up in the last exam or the previous exam. Specifically, the conversion of a share block into a sectional title, what the provisions of section 8A is that are the requirements therefore, and for you to know how to draft the causa of the conversion and the 15B3 certificate that must be provided for the conversion of a share block into a sectional title unit and the transfer thereof. In a nutshell, it's only 2 pages in my book on share blocks, and I've given you examples of the 15B3 certificate and the different scenarios that cover that. The Spatial Planning Land Use Act 16 of 2013. Now they've given you numerous sections there, 220. The most important section there is section 53. Now, as I told you, ladies and gentlemen, the Spatial Planning and Land Use Act 16 of 2013 has repealed the Less Formal Township Development Act. It has repealed all the municipal ordinances, and this act is now the umbrella act that governs all land development applications. And there you will find a definition of a land use and a land development and a land development application, opening of a sectional title scheme, etc., etc. However, every council has its own bylaw or regulation governing the Spatial Planning Land Use Management Act. So, for instance, if I say to you, for opening of a sectional title scheme in Pretoria or in Tshwane, we need a SPLUMA 2610 authorization. But if I open it in Ekurhuleni, I don't need it. For the extension of a section in Tshwane, I need a 2610, but under the Joburg town planning laws, I don't need it. So once again, it's going to be very difficult for an examiner to ask you something on the Spatial Planning Land Use Act, because each of the regulations governing that council differs from council to council. I believe that section 53 is the most important one, because that is the section which is the umbrella section, and then the definitions of what is a definition of a land development or a land development application, or what is a land use, what is a land use scheme. I would restrict myself to that. The Subdivision of Agricultural Land Act. They say the entire act. Guys, I say section 1, the definition of agricultural land. Now, it's so ironic that I also want to say to you that this act you study in conjunction with Chief Registrar Circular 6 of 2002. 6 of 2002. Because the Act says agricultural land is all land not situated in the jurisdiction of a local authority. Now, if that was so, we wouldn't have agricultural land anymore. But the minister in 2002 said only she would decide what land is agricultural land and what is not agricultural land. So at this point in time, any land with the word farm in the property description is deemed to be agricultural land and is subject to the restrictions contained in section 3, unless the minister says it's not agricultural land. So that's important. Section 2 tells you what transactions are exempt from the provisions of the Act. Section 3 says to you which transactions cannot take place if it is agricultural land. Section 4 says to you, if you cannot get the consent of the minister, what must happen to the property? Must be sold, or redistribution agreement must be entered into, or whatever the case may be. Section 6, capital A, tells you which servitudes can be registered without the minister's consent. Servitude of a width more than 15 meters, servitude ancillary thereto not bigger than 225 square meters, or a usufruct over the whole of agricultural land. Also note on which lease agreements cannot be registered over agricultural land. So once again, read this Act together with Chief Registrar's Circular 6 of 2002. Note on the provisions of Section 6, capital A. In my book, I have a whole full discussion on the subdivision of agricultural land. I refer to all the case law and the Chief Registrar's circulars which exempt certain transactions from the provisions. For instance, if you are going to transfer to two heirs and immediately they form a company and they transfer it into the name of the company, that will not be a contravention of Act 70 or 70 because there's a Chief Registrar's circular. A habitatio for less than 10 years does not need the consent. Above 10 years, yes. However, there's a court case that says possibly not, but the Chief Registrar has not withdrawn her circular as yet. High Court Rule 63 and the Hague Convention. Important, important, important. This governs the authentication of documents executed outside the Republic of South Africa for use within the Republic of South Africa. Now, guys, I published an article, and if you Google it, rules of authentication, I tell you which countries it can be authenticated in front of a notary. If it cannot be authenticated in front of a notary, who must authenticate it? If both countries are part of the Hague Convention, it must be done in the form of an apostille. Please try, even if you Google it, Google me, Google authentication of documents, print that, because that will give you the full discussion on Rule 63 and the Hague Convention. The Transfer Duty Act. Very important. And I know you're going to ask me, are we going to get a question on the calculation of transfer duty? And I can almost put my head on a block and say to you, yes. So once again, Section 1, definitions. Section 2 will tell you at what tariff transfer duty is payable. Now, Anton, and you can ask him this when you do get the opportunity to speak to him, your transfer duty will be as at date of writing the exams. You don't have to worry about the date of the transaction to go see what the tariffs were. You will use the tariffs as at date of transaction, okay? So Section 2 says to you at what tariff. Study Section 2 in brackets 5, because that tells you if you acquire an undivided share in immovable property and it is subject to transfer duty, transfer duty will be calculated in terms of a formula, and the formula is Y equals A over B times C. Now you're going to tell me, what the hell is this? Now I must study theorems. No. All that Section 2.5 says, you will calculate the transfer duty in terms of the sliding scale on the full value of the property and divide it by the share. For instance, I buy a half share for R1 million. Now we know that the first R1 million is exempt from transfer duty, am I right? So I buy 1/2 share and I don't pay transfer duty. I will pay transfer duty on 2 million divided by 2. according to the sliding scale. If I buy a quarter share, I will pay for $1 million. I will calculate transfer duty on 4 million and divide it by the denominator. That's important. 2.5. Section 3 is not so important. Section 4 is the calculation of the penalty on transfer duty if transfer duty is not paid within the period of 6 months. Now, many times they ask, within what period of time must transfer duty be paid? And you know what candidates write? 6 months. 6 months of what? And I hear you saying 6 months of the date of registration. No, 6 months of the date of transaction. And the date of transaction is when there was consensus obtained in respect of the deed of sale. When the deed of sale came into existence, that is when the 6 months starts running. And if it's not paid within that, it's 10% on the unpaid amount calculated for each month that it was unpaid. So that is section 4. Section 5 tells you on what amount transfer duty is payable. And that has been asked so many times in the past. If it's an exchange transfer, on what amount will transfer duty? If it's a donation transfer, on what amount will transfer duty be payable? If it's an auction sale, on what amount will transfer duty be payable? So the whole of section 5 is extremely important. Section 6, 7, 8, 9, 9, the exemptions, specifically section 9(1)(e). Important, important, important. Section 16, if property is bought on behalf of a person or his nominee, what are the transfer duty implications there? But once again, if you look at my chapter in my book, I've discussed all these sections categorically and gave you a discussion of it. Maybe, I don't know, I'm not privy to Gawie Leroux's notes, but possibly Gawie Leroux's notes has it as well. The next act is the Trust Property Control Act 57 of 1988. Guys, section 1, the definition of a trust. Now we get an oral trust, we get a testamentary trust, we get a inter vivos trust. So there's many different trusts. Okay, so look at the definition of a trust, look at the definition of a trustee, as well as section 2, the registration of the trust, section 6, the appointment of the trustees, that a trust cannot acquire property before the trustees have been appointed and the trust has been registered in terms of section 6. In this Trust Property Control Act, a question that hasn't come up, but I get this feeling, can a foreign trust acquire property? Can a foreign trust acquire property in South Africa? I get this question so many times that conveyancers phone me or email me and they say, I can't find anything that a foreign trust cannot acquire property in the Republic of South Africa. If we look at section 8, read together with the conference resolution on that, and a full discussion once again in my book. A foreign trust cannot acquire property until they have been registered as a trust in South Africa and trustees have been appointed. Only then can they acquire property in the Republic of South Africa. Value Added Tax Act. Here, look at all those sections. I'm going to break it down and I'm going to say to you, you must know specifically at what rate VAT is payable. When is it 0 rated? When will it be at 15%? Who is liable for VAT? Is the VAT transaction? Is it not a VAT transaction? If it's not a VAT transaction, transfer duty will be payable. If you look in my book, I've got a schedule for you. If this happens, it's VAT at that rate. If this happens, it is transfer duty at that rate. If it's a 0 rated, these are the requirements for a 0 rated transaction. That is what you must know in terms of the Value Added Tax Act 89 of 1991. Provincial ordinances and bylaws, you can scrap it. Because as I said, bylaws they can't ask you, provincial ordinances, however they can ask it in the oral exam if you're going to get an oral, but I'm sure you're not going to get an oral. Resolutions of registrar's conference which impact on the law, practice and procedure. As I said, we've sent you the majority of the conference resolutions. I can tell you that we've got a book, and you can buy the book. We got the conference resolutions consolidated from 1938 up until 2000. You haven't got time to do that. You must look at those conference resolutions that affect your practice on a day-to-day basis. Look at the last 5 years conference resolutions, because that's where your short questions are going to come out of. Then they said any regulations issued in terms of the aforementioned acts and ordinances, that's what I've already referred to. The housing development schemes for retired persons. Guys, you see here they say candidates must also study the following, have sufficient knowledge for 10% of the marks in any given paper. I'm going to leave this up to you. As I said, if you've got time and you can study the housing development schemes for retired persons, that's fine. If you can study the Property Time Sharing Act, which I don't think is relevant at this point in time, that's fine. The Restitution of Land Rights Act, that's fine. The Upgrading of Land Tenure Rights Act, as I said, has been found now to be unconstitutional. The Extension of Security of Tenure Right Act, that's ESTA, only Section 1, you can look at that. The National Credit Act, questions have been asked on the National Credit Act. Look at all the questions that have been posed on the National Credit Act. The Extension of Security of Tenure Right Act, that's once again, that's 62 of 1997, that you can decide if you want to study or not. I'm not going to be prescriptive in that. I think there are other acts which is much more important. We know that the Registrar's Conference resolutions, the Chief Registrar's circulars, the relevant Registrar's circulars, however, the Deeds Practice Manuals, although a very, very, very valuable document, it's not available anymore. I don't know why it's still here, but it has been discontinued for members of the public since 3 or 4 years ago. So you're not going to get hold of that at this point in time. Guys, and that is paper 1. And now, as I said, what we're going to do now is we're going to ask for questions and answers. I just wonder if I go out there now. Am I going to have there? I'm back on camera now. And now it is time. We've actually got almost 35 minutes for questions and answers. So if you have a question, put on your mic one at a time, please. Put on your mic and ask the question, and I'll, if possible, answer it as comprehensively as possible. If you haven't got any questions, you can say goodbye and you can go start studying. Hi, Lizelle.
Hello, Alan. Thank you. It's been really, really good to be on the session. I just want to speak with you, if I may ask a question. In terms of SPLUMA, land development applications and land use applications, when a developer wishes to open a sectional title scheme, is it necessary to get an approval from SPLUMA?
Once again, it depends on your bylaws. As I said, the bylaw of Ekurhuleni says no. The bylaw of Tshwane says yes. The one of Joburg says yes. They've even changed the one of Joburg now. I just got a circular, a registrar's notice from Joburg saying that the opening of a sectional title scheme is deemed in terms of their section 53 to be a land development application, and therefore it's necessary. So, Lizelle, to answer your question, it's very difficult for me, and that's why they won't be able to ask this specifically in the exams, because I don't think, and I'm not being facetious when I say this, but I don't think even the examiners know all the bylaws of all the councils for purposes of asking that question. To tell you the honest truth, I don't know what the bylaw of Cape Town says with regard to that.
Indeed. So if we are asked in the exam, if our candidates are asked in the exam to list the supporting documents when they're asked to open a sectional title scheme, what would one in this regard then say?
What I say to the candidates, I say SPLUMA if necessary, or you know, yeah. But that's when you're really going for your book prize, eh? but if you can say spluma if necessary, because we don't know what bylaw it is, it might be Cape Town or whatever. So I would, if I want to be overcautious, ex abundante cautela, I would say spluma if necessary.
Thank you. Thank you for the answer.
You're welcome. Any other questions? I don't believe that there are no questions.
Alan, if there are no other questions, I would like, but I don't want to interrupt other students, so I'll just wait first.
Not at all. You know, your question is a question that they also will benefit from. So please, Lizelle, fire away.
Yeah, hi, Alan. It's Alan Jackson from Cape Town.
Hi, Alan. My namesake. Your name is spelled wrong, Alan.
No, Scottish.
Okay.
So my question relates to the Administration of Estates Act and then adiation and repudiation. Are you going to cover that a little bit more later?
I'm going to try and cover adiation and repudiation when I do estate transfers, which is, Alan, very, very important. Because I even got a question over the weekend that a candidate, and I think the candidate is listening, he said, and his question was as follows. A and B are married in community of property. They made a joint will. They massed their estates. On the death of the first dying, the survivor repudiated the will. Does that mean that she's entitled to 1/2 share by virtue of her marriage in community of property, and the other 1/2 share will inherit interstate? And I thought, how is it possible that you bring interstate succession? And then I realized what he's thinking now. Because of the repudiation, this other 1/2 share will then not devolve, but that forms part of the remainder of the estate, if you understand what I mean. And that'll devolve in terms of the will. If there's no provision in the will for that, yes, possibly it can devolve interstate.
So that portion I understand quite well. That's not what I'd like to understand is there is a segment that says when the will fails, only then does it go to intestate. Correct. What I'd like to understand is any information relating to how the will fail. Is there any guidance in that respect?
Well, you see that is a whole different sphere of our law, and I don't think that is of importance for purposes of this exam. They will either say it's repudiated and this happens. So your question in the exams will be clear, Alan.
Okay, so I don't have to worry necessarily about if the will fails or whatever.
Absolutely not. That okay. I can guarantee you.
All right, that settles my mind. Thank you very much.
All right.
Alan, then I'll ask another question, if I may. Lizelle again.
Absolutely, Lizelle.
The Recognition of Customary Marriages Act was very recently amended. Section 7 now, if I read it correctly, it is confusing. I'll have to go into it carefully. But if I read it correctly, it has been amended in respect of marriages that were concluded before the Act came into existence. And the one important amendment that I want to ask you about, it appears to me now, because it's difficult to ascertain, who gets what if there are more than one spouse. They've now stipulated, and it seems to me to be sort of a new third property, marital property regime, if you like, where a distinction is drawn between family property, house property, and marital property. I hope I understand it correctly, but it appears to me that house property plus family property equals marital property, but personal property is excluded. That's not marital property. So my question, in terms of what is it, Chief Registrar Circular 27 of 2013, there's a description for marriages that took place before, for polygamous marriages that took place before. And then the chief registrar says how one should describe that. And that's a fairly full description. It says custom in terms of the recognition. But then for marriages after, if you look at that description, it merely says married in terms of customary law. I can't quite figure out why the difference, and secondly, would that change now as a result of this new third regime?
Thank you, Lizelle, for that question. And I've canvassed this very thoroughly with the Chief Registrar as well. The amendment, and in terms of the Constitutional Court case, and the amendment of Section 7 does not affect the Deeds Office practice at all. So if you were married in terms of customary law prior to 15 November 2000, your description will still be in terms of customary law, if you understand what I mean. If it's after the 15th of November, it will depend whether there was a contract entered into or court order entered into in terms of Section 7.6, and then there's that description. So once again, just to answer your question from a conveyancing perspective, 27 of 2013 stands as it is. The parties that have entered into that customary marriage prior to the 15th of November 2000, obviously they have certain rights which they can claim in terms of customary law, and not discriminatory as such, but does not affect our practice of conveyancing.
Thank you very much for that answer.
Hi, Alan, it's me again from Cape Town. I noticed...
Alan, why do you say from Cape Town? Are you making me jealous or not?
No, I don't know why I said that. I'm sorry.
You have to be made jealous. Thank you.
Yeah, look, the weather's nice here today, so maybe I'm bragging. But in the list of acts that we've been through now, I noticed that you left out the Sectional Title Act itself.
I left out, Alan, I'm sorry, I'm interrupting. I left out the Sectional Title Act and I left out the Deeds Registries Act. And I said those two acts in its entirety in the beginning must be studied. But why I left it out, it's because we're going to do those two acts when we do paper 1. And when I come to sectional titles, I'm going to go through the whole of the Sectional Title Act with you, specifically the consolidations, the subdivisions, the extensions. So please, I left it out specifically, but maybe you came in a bit late. It's so important that we're going to deal with that in totality when we do the next 3 sessions.
Okay, all right, thank you. That's good.
Alan, I don't hope that you thought that it's not important.
No, I was just querying because the list, I understand the importance of the document and knowing it all. It was just that I just picked up on my list that it wasn't addressed, but I think I might have missed your initial DRA STA in the beginning.
Sure.
Yeah. Thank you.
You're welcome. Guys, there's 85 other people and I can't believe they haven't got questions. Maybe I did such a good job that there's no questions, but you know, what we can also do is please, you know, what I propose now is that for our next session, and that's next Monday, 2 hours, I'm going to obviously do the deed of sale, I'm going to do the power of attorney, and I'm going to do the deed of transfer. And I'm going to try and do all the supporting documents and other transfers, what do I call it? Not transfers by endorsement, but PACA endorsements in terms of Section 31, 33, 26, etc. So if you can just please do yourself a favor, prepare for next week so that when you come and we do extending clauses, this is so important because I'm going to do extending clauses next week. All the extending clauses have already been asked in the exams. If you can please just go to your old exam papers and look at those. But remember, there's certain memorandums doing the rounds that are wrong. There was a conference resolution in 2016 which says when you deal with the remaining extent, you must now refer not to the general plan but to the mother diagram relating thereto. So please don't study wrong memorandums. I urge that, but go through those questions, and if there is a question that you want us to discuss in our 15 or 25 minutes next week, you're more than welcome.
Alan, I see that on the chat there are, I see 2 or maybe 3 questions that have been asked in
I
writing.
don't see the chat. Have you got the chat in front of you?
Certainly. The first
Can
one that
you read it to me?
certainly, the first one says, please show us calculations on transfer duty. And the second one says, in terms of registrar circular question, hang on, let me just page down. In terms of the registrar circular question for the exams, do we have to refer to the specific number and state what it says?
Okay, the second question first. You never need to refer to sections or conference resolutions or circulars by name or by number, except when you're drafting deeds and documents. Obviously, if you're bringing an application in terms of section 45, you have to refer to the section. And in the body of the document, you have to refer to the section. I sometimes confuse candidates by fully referring to this section and that section, etc., etc. In your second or in your first paper, if you got the contents thereof, that's fine. Okay. The first question was, show us the calculation of transfer duty. Guys, it's 0% on the first R1,000,000. And then it is the percentages that follow thereafter. And Anton will also tell you, you have the authority to take in your calculator. However, the question will always be posed in the following format. Show how you calculated the transfer duty. So your first will be 0% on the first million equals R0, then 3%, then 5%. And if you got all that and you add it up wrong, you will lose 1 out of 5 marks. So don't just use your calculator and calculate it, if you understand what I mean. Kathleen also asked, do we have to know the sections off by heart? No, Kathleen, if you have to know all the sections off by heart, you will never pass this exam. Never in your whole life will I even pass this exam. And I'm not trying to boost myself now. I do know, having 47 years of experience, I do know certain sections off by heart, but you must know how to apply these sections in practice. I hope that answers your question, Kathleen. Was there another one, Lizelle?
Yes, there's one more that I can see. It says today's webinar, is it primarily for paper 2? So I think that perhaps just to...
Other way around, primarily for paper 1.
Alan, would you please explain to us what happened? Because the paper 2 and paper 1 was swapped around. Maybe there's a bit of confusion about that. I think 2017, eh?
Yes, look, it's been swapped around. The first paper, which consists of short questions, is designed to test the knowledge of candidates of various statutes, ordinances, and decided cases applicable to conveyancing. 100 marks. Previously, paper 1 was the drafting and drawing. That was the 4-hour paper. And then on the same day, you did the 2-hour paper in the afternoon. That has been swapped around now. So paper 1 is your short question paper, your 100-mark paper. And paper 2, which is going to be on the 8th of September, is designed to test the competence of a candidate, mainly in the practice and procedure of conveyancing. It consists of questions which require candidates to draft such deeds, certificates, applications, consents, agreements, and other documents, as will indicate whether candidates possess enough practical knowledge. 200 marks will be awarded for that.
Thank you. There's another question, Alan. A student is asking, what must I study for next week's class? In other words, students want to know what to prepare to be best.
Well, I think I've just said that next week we're going to start with the deed of sale, then we're going to do the deed of transfer, then we're going to do other formal deeds of transfer, then we're going to do supporting documents. Now, when we do the deed of transfer, we're going to analyze the deed of transfer. We're going to obviously do the, I can't, and here I want to say why I need them to prepare. When I say A, who was married in terms of customary law after the 15th of November, transfers the property. He must know he's going to describe the person as in community of property. Or if it's a if it's a civil union and it's not a marriage, he must be able to apply Chief Registrar Circular 1 of 2007. And once again, if you go to my book, in the chapter on description of parties, and please guys, I'm not tapping myself on my back or anything. Other persons have the same notes as I, but I give you a description of a person in the deed of transfer and in the power of attorney, in the vesting clause and in the preamble of the deed, and in the preamble of the power of attorney and in the vesting clause. So too with mortgage bonds. And that I try to do as comprehensively as possible. So for next week, we're going to do deeds of transfer and deeds of sale. That's what we're going to do next week. Extending clauses as well. And Anton is sitting behind me. I don't think you can see him, but when I said extending clauses, I see him shaking his head, because extending clauses are important. It gives you the history of a piece of property. And without knowing where that property comes from and where, by which title deed it was held, you will not be able to determine the history of a piece of property. So extending clauses are extremely important. Tembu says, I do not have lead study guide. Tembu, lead study guide is a very comprehensive little booklet. Lead study guide is exactly what it says. It's a guide. It is not sufficient for you to prepare sufficiently for the exam. You can use that in conjunction with any other study material. That's why I said that's fine, but my book, I prescribe my book to candidates that are sitting in front of me. And Lizelle will also tell you she prepares her conveyancing students, and she insisted that each of her conveyancing candidates obtain a copy of this book. If you've got Gawie Leroux's notes, that's excellent. But don't think that you can go into the exam with Leeds guide, because it's just a guide. I must share this with the candidates. Anton and I in the past, I just want to answer when answering a question, do we need to refer to the sections? No, you don't have to refer to the sections. If you refer to the sections, hallelujah. And I think you will impress the examiners by no end, but no, you don't have to. Somebody asked, will the link open? I didn't get that question. Will the link open when something happens? I just want to get back to the question that Anton and I in the past had what we called a post-mortem, and we got candidates in that really felt that they did pass the exam, but they don't know why they only got 12%. And the one guy came to us and he said he doesn't know why he got 12%, because he's got an LLB which he cummed, and he's got an LLM which he cummed, and he passed all his admittance exams, and now he gets 12%. And we asked him, just by the way, sir, what did you use to prepare for the exam? He says, I have got a note from UNISA which says Introduction to Conveyancing and Notarial Practice, and I used this. And why don't you ask questions on that? Because you always ask the exception to the rule and not the rule. Now, that's absolutely not true. And when we explained to him, he went away, and he was not a happy chappy that we told him that he didn't have the correct study material. So once again, and then I get a guy phoning me and saying to me, I've got your 1988 loose leaf book. Is it still, can I still use it for this exam? Please destroy that, burn it, throw it away, or use it. It is history. If you haven't got the 2018 or 2020 book, please don't try and use the other books, because they're going to confuse you. And then it's the same as people coming to us and saying to us, I studied from Gawie's notes. And we say, yes, where did you get Gawie's notes? No, I got it from a candidate that studied the exam 10 years ago, and he gave it to me. And then he says, but Gawie's notes say so. Yes, Gawie's notes of 10 years ago says so. But it's changed, and Gawie's notes changed. Maurice asked, where can we buy your book? I've asked Andries to send out the link of LexisNexis, which gives you the authority to get a discount on buying my book. As I said, I'm not punting my book. Please believe me, I'm not punting my book. But if you want to buy my 2020 book, it is being given to you because you're attending this seminar. Sorry, somebody asked about last year's papers. I missed that question. Can you just put up that question again? Last year's papers did what?
I'll read that for you. Last year's papers did last year's paper ask specific questions? Is this year's papers any different? E.g., list the requirements of an agreement, and then I can't list the requirements of an agreement between the home builder and housing consumer in terms
that was specifically Section 13 of the Housing Consumer Protection Act and the court case. And it is the contents that yes, because that is one of the sections that was proposed for you to be able to know. So yes, a question like that can be posed again. There's no problem in asking that question because it is of such utmost importance for the conveyancer. So for instance, they can ask you what transactions are exempt from what servitudes are exempt from the provisions of Section 6A. Then you must quote them. Luzanne says it's best to know the section and know what it says. Yes, but if you know the section and what it says and how to apply the section in practice, and I can't stress that more. It's no good be able to recite a section and don't know where it fits in. I'm specifically thinking of Section 21 of the Deeds Registries Act. People can recite all the exceptions to Section 21, but don't know how to apply it in practice. That's ludicrous.
So, Alan, just to be clear, some sections are so important that one definitely has to know them.
The content, yes.
The content. But you would not be, if I'm asked to draft a certificate of registered title in the exam, I wouldn't have to say this is a certificate of registered title in terms of so-and-so, unless obviously the form states it, and I've got that I'll get from the form anyway.
Lizelle, to answer that question, very seldom will they ask you to draft a certificate of registered title. They'll give you a set of facts and ask you to lodge to draft the application for purposes of that certificate of title. And then you must know it is either Section 34, 35, 36, or 39.1 or 39.2. So yes, but you know, drafting, you have your act in front of you, and you have all those prescribed forms. And I always say, Audrey Gwangwa uses the word called, I don't like it, but she uses the word cheats. You can cheat with your prescribed forms to draft the application. And then you must know which section it is. Otherwise, you're going to get 0. If you tell me it's an application and you don't tell me it's in terms of Section 34, not me, the examiner, 34.1 or 35 or 36, then you're going to get 0. I also want to set the record straight. I see there was a question now. Leeds notes refer to one of my other books, the practitioner. Look, my book is The Practitioner's Guide to Conveyancing and Notarial Practice, and then there's a conveyancing practice book, which was previously the late Mr. John Christie's book, which I updated, I think, in 2014. That book has been discontinued. So draw a line through it. It is outdated and it is not available anymore. The only book that is prescribed, that should be prescribed, and this is what we told Lead, if they want to prescribe a book, it is the Conveyancing and Notarial Practice. The other book has been discontinued.
Alan, if I may, just in terms of your book, one comment and one question. I've had the privilege now just for over a year, well, for a few months again, after I haven't been involved in conveyancing for quite a long time, I had to apply my mind and to decide which are the best sources and how should one approach the exam. And I have no doubt that what you've said is absolutely correct. The best notes, if people are going for study notes, as it were, is Harvey Leroux's notes. But the best book, and at an exceptionally good price, I think it is very reasonably priced, is your guide. So I have also prescribed your guide to my students because it is 100% up to date. And one will not have, there's no risk of citing outdated information. So I do find your guide extremely valuable, especially as you refer to the most important CRCs and chief registrar circulars, because one doesn't have time to go and, refer back to 1994 and read through all of that. So your book is certainly extremely useful. I also find that for candidates who are worried about, not having enough resources or sources, if they have your book and if they have the acts printed out or online as per the syllabus, or even Leeds' book, then you've got what you need. And the rest, you gave some very valuable tips in so many articles that you put online free for all. So if one is confronted with something that you don't quite know, what is a collective scheme investment thing, or if you haven't attended the course and you don't have the benefit of that deep and rich context, then it's very easy to Google it online. And if you see an article by Alan or by Tonkin Clacy, which is the firm that Alan is associated with, then you can know that it is current and that it is valuable and good information that you can trust. So I also find, in addition to your book, sorry, I don't mean to, to pat you on the back, I'm also just stating the facts because I think that's what students need. Your work is exceptionally accurate, it's good, it's reliable, it's informative, and for the most part, what you find on the internet is 100% free and may be shared.
Lizelle, thank you so much. I'm not going to pay you royalties for this scene, but thank you so much. And yes, once again, I also say to candidates, specifically when you're in practice, don't say Alan West says. In my book, and if you look at my prelude to my book, I say with every statement I make, I try and substantiate it as far as possible with authority, because it is the authority that you must go to the registrar with, not with a book, because it can boomerang, if you understand what I mean. So since I started at the Deeds Office, I was canvassing for a uniform practice, and I don't think in my life I'm going to get a uniform practice in the 11 deeds registries. But my book tries as far as possible to substantiate everything, either with a conference resolution, a registrar circular, a chief registrar circular, or a court case. So, but thank you very much for that, Lizelle. And, I try as far as possible to assist where I can, and I'm open for criticism. If some people tell me there's something wrong in your book, that's perfect. Somebody asked me how much does the book cost. The link that LexisNexis sent Mr. Modiba to send to you gives you the price of the book minus the 15%. Now, I think it's something like 712 Rand or 720 Rand with a discount, and delivery takes place within 3 days that they promised me. Guys, I think I've exceeded my time, and I know we can sit here till 12 o'clock tonight, but I've got a wife and a dog that I have to go home to. So I'm going to love and leave you, and I'm going to see you and hear you next Monday, and then we'll take it from there. But please, you have got a month, more than a month, to prepare for this exam. It's not an exam that cannot be passed the first time. I have many candidates that have come to me and said, I've passed the exam the first time. It depends on what you put in, what you're going to get out. If you're not going to put in, you're not going to get out. So enjoy your evening, and no more beers in the evening. It's just swatting until the 7th of September. Good luck, guys, and I'll and see you next week.
Sorry, Mr. West.
Yes.
Sorry, it's Elizabeth. Yeah, I just have 2 questions, quick ones. I just want to know your latest book, is it the 2020 edition?
2020.
Or is there 2021?
No, they'll crucify me if I bring out a book every year. So
Okay.
It's the 2020.
Yes, I have that one. Okay. And then my second question, parties married in terms of Muslim rights,
Yes.
or according to Muslim rights,
Yes.
are they still described as such, or is it?
You know the new constitutional court case, as well as the chief registrar circular. Previously, we had an option of describing people that have been married in terms of Muslim rights as unmarried or married according to Muslim rites. Now, you cannot use the word unmarried because that marriage has been recognized. The consequences of that marriage hasn't been decided upon yet. That is, the legislation must come out for that, and they've also given a 2-year period. But please, and Muslim marriages I'm going to discuss next week again. Remember, there's a difference between a Muslim marriage that was solemnized by an imam that's not a marriage officer and an imam that has been ordained as a marriage officer. If he has been ordained as a marriage officer, it is a civil marriage in terms of the Marriage Act, and then he's described as in or out community of property. If it's just an imam, it's a religious marriage, and it will not be a civil marriage in terms of the Marriage Act. I hope that answers your question.
Yes, thank you very much, Mr. West. Appreciate it.
Welcome, guys.
Okay.
All the best.